Hello my friends, my name is Sagir Ahmed and I am before you to present this video on behalf of our law firm and under the aegis of our pro bono unit services. We are presenting before you this video in which we will talk about the history of land revenue system in India and its evolution. Now from the very beginning of the civilization, if we talk about the Vedic period in India, it also involved the collection of revenue and taxes from the livestock, lands and the crops grown over it. Now basically what revenue is all about. Revenue is all about collection of taxes on the things which the particular people living in the vicinity of that particular area who produce something which gives benefit to the society in terms of their sustenance, in terms of their consumption. In that case, that particular crop or that particular produce has its a particular share to the government also, or to the ruling dynasty, whatever. Now Vedic period talks about how the taxes were collected during those days. Basically this is found that 1/6 part of that produce was given as tax to the ruling regime. Now after Vedic period, if we talk about Mauryan Empire, they themselves have their own system formulated for collection of revenue and taxes. And then comes the Khilji dynasty. They also had some systems developed for collection of revenue in India, in Indian subcontinent, obviously. Then Mughal dynasty came. They have their own system, and among the Mughal dynasties, different regimes, different rulers. The most famous one was Todermal's tax revenue collection system was. And after that, Sher Shah Suri has also his own significant collection and formulated, very good, properly formulated system of collection of land revenue, which is praised till date. And then we had colonial rule, which was established in India, and they also gave us very different form of land revenue collection, which were more advanced and more developed than the earlier ones. Like those were, among those four major ones were like this Izaredari system, Zamindari system, Rotwari system and Mahalwari system. All these systems were basically designed to meet the requirements of the government to collect in a proper and proper facilitation of collection of land revenues and taxes. If we basically talk about taxes now, taxes cannot be same among all the produce, because produces are different in nature, are different in their functioning, and different in their consumption, and different in their usage by the common public. Now these systems were four systems were basically developed during the period of 200 years by the Britishers, subject to the availability of land in the particular subcontinent of Indian land, like this Bengal side and Gujarat side, and that Kashmir and north side and east side, and different systems. Like if you go talk about the Madras and Assam and different systems, different land systems, they were all developed to collect the revenue based on the crops and the fertility of the land. Now what happened was, I give you a simple example, like if a land produces rice, and there is a land which produces potatoes. Now the same form of taxation cannot be implemented or imposed on both the crops, because of their nature, of consumption, and because of their different variety. If 100 rupees of a sack of rice is collected, and here is 100 rupees a sack of potato is collected, I'm just giving you an example. So the collection of revenue out of that 100 rupees of rice could be different, and the 100 rupees of that particular potato could be different. So this is the system, how it is developed, how the collection of that revenue is managed. Then in 1901, a new law was introduced, Uttar Pradesh Land Revenue System. I will be now precisely focused about the Uttar Pradesh only, because we belong to this particular land. The state, law of this state of land is different. Now, UP Land Revenue Act 1901 has 14 types of tenure holder. Now, let me tell you first what this tenure holder is all about. A tenure holder is someone who gets the right from the government or the proprietor to have the possession over the land, to grow crops, to collect rent, to establish tenants. Okay, it is very simple. There is nothing very fancy definition about tenure holder. There are numerous ones. So this particular person, tenure holder, has the right over that particular land. Now there are types of tenure holder, which are namely four. The Bhumidhar with transferable rights, Bhumidhar with non-transferable right, Assamese, and government leasee. Now all these four are different forms of tenure holder, like how, in what manner your that grant has been made to you for collection of land revenues and for collection of rents or taxes. And it is a different topic. There are numerous acts and numerous laws which entails about the collection and all these transferring of the properties and letting, subletting, lease and sublease. That is something which we will cover in different videos of ours. So after this 1901 Act, UP Land Revenue Act 1901, there were 14 types of tenure holder, which was brought down to 4, which I told you. These 4 types of tenure holders, there were 14, which was very difficult for people to understand, for the courts to adjudicate. That is why the new system was introduced, which was in 1951, UPZALR, which is known as Uttar Pradesh Zamindari Abolition and Land Reforms Act, which talks about only this 4 types of land revenue system. These systems were also very beautifully worked upon. Court were not facing that much of difficulty in adjudicating the issues regarding the land revenues and different inconsistent laws. That was very good going. But after some times, there were some frictions and inconsistencies between the governing of law and collection of revenue, and then the cases were piling up in the revenue courts and the consolidation courts. So what happened was, the new land revenue code were developed in 2006, UP Land Revenue Code 2006, and after that new rules 2016, UP Land Revenue Code 2016 was also developed, and they both are not different. They both work in you can say they both work in you can what do we say, in a proper way, in a dependent manner they work. So what this code all about? This code is about like 39 laws which were obsolete were replaced in the 2006 code, and the basic idea behind 2016, if I say tell you, is the UP Land Revenue Code 2006 is a substantive law consolidating land tenure and revenue laws, while the 2016, while the UP Land Revenue Code 2016 provides the procedural framework for implementing it. And if we talk about the modernization which has taken place in these acts, like digitization, modernization has taken place. GIS mapping, GPS mapping is introduced for proper mapping, proper measurement, and proper measuring and properly facilitating the land revenues. And both these codes, 2006 and 2016, they both work together. And as I told you, one is substantive in nature and the other one is procedural in nature. Now, it also holds the gender equality, like it also recognizes succession rights of the unmarried daughters and third gender individuals also, which is very good. And Dalit rights were also considered and approved by the introduction of these acts. So it is something which gave the land revenue system and the land revenue collection system of this Uttar Pradesh especially a new established uh, practice, without going into the intricacies, without going into the inconsistencies which were there in the previous land revenue acts and systems. So I hope you all understood the history of land revenue system and its evolution in a very short. Uh, Nothing, it cannot be brought down to more short video, and it includes all the system from the from how it has evolved from the Vedic period to this date. And we will also cover some other things which I discussed in the middle of the video in our upcoming videos. Thank you and have a nice day.